Hello everyone, my name is Alexander Nam, and I'm a law clerk here at Lyles Partner. Welcome to today's webinar hosted by the Home Care Association of Louisiana. Today's webinar is entitled Hospice, TPE, CERT, SMRC, SFP, PPEO, and UPIC audits. Top denial reasons and the possible impact of these audits on other enforcement activities. Today's presenters are Christin Thompson and Matt Catoe. Christin Thompson is a senior associate here at Lyles Partner. Before joining Lyles Partner, she worked as a professional coder, assigning diagnosis and procedural codes for urgent care, inpatient, and outpatient facilities. She has experience identifying documentation deficiencies and auditing claims for a variety of practice types. Christin assists providers nationwide with developing and implementing policies to improve documentation and coding practices. Our next speaker, Matthew Catoe, is an associate here at Lyles Partner and focuses on healthcare regulatory compliance matters. Matt has experience with auditing claims, the anti-kickback statute, and Stark law allegations, and assisting clients in regulatory cybersecurity compliance. He has also assisted providers with medications and compliance documentation when on appeal. As a quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box. We'll address as many as possible at the end of the presentation. Without further ado, I present to you your speakers.
Thanks, Alex. Okay, so we'll be looking at enforcement actions throughout this presentation, including federal enforcement criminal cases, Civil False Claims Act, investigations conducted by the DOJ's fraud section. We'll also take a look at administrative actions like TPE, UPIC, CERT, special focus audits, and new program audits like the PPEO program. I'm sure many of you are familiar with and probably just as aggravated as we are with. Next slide. As a quick disclaimer, this presentation is provided as general information only. It does not constitute legal advice and should not be used as a substitute for seeking legal counsel. All right, next slide. So a bit of federal enforcement here. In September of 2022, the Deputy Attorney General updated previous guidance issued the year prior in October. She reiterated that the department's first priority in corporate criminal matters is to hold accountable the individual who commits and profits from corporate crime. As a result, the personal liability of a home health and hospice agency owner, employee, contractor has dramatically increased. You cannot expect to avoid personal liability by hiding behind your organization's settlement with DOJ or OIG. In making determinations, the corporation's compensation agreements, arrangements, and packages are all assessed to determine penalties to be levied against current or former employees, executives, or directors. Next slide. So in the past, in the most recent past, in the post-COVID era, we're seeing a significant uptick in enforcement efforts. Year-over-year review shows 2021 settlements and judgments peaked. Settlements and judgments in 2024 still exceeded $2.9 billion. More than half of that was attributable to healthcare-related cases and matters. The 2024 numbers do not include approximately $1 billion from 2 settlements that closed just after the 2024 deadline. And whistleblowers filed a record-breaking 979 cases in 2024 and were party to 558 settlements and judgments. That's a huge number. And we're seeing more and more of the whistleblower cases come in for review and consideration before filing. Next slide. DOJ's criminal fraud section is the focus these days. Healthcare seems to be their crowning jewel. Criminal prosecutions make up the vast majority of all criminal cases pursued by DOJ's fraud section. Prosecutions under the healthcare fraud unit focus on federal healthcare benefit programs. Most recently, we've seen 147 individuals charged through healthcare fraud unit investigations and 165 individuals convicted either at trial or through a guilty plea. These charge and conviction rates are near double the closest second unit, which is the market integrity and major fraud unit. And they focus on, fraud involving bank, mortgage, securities, and other financial and investment programs. So you can kind of see that healthcare is playing a huge role. Banking is coming second to that, and it seems almost counterintuitive, but that's how much of a focus healthcare is right now. Next slide. Since 1992, most companies that were criminally prosecuted and subsequently sentenced have been domestic, private, and small companies. Most of these organizational offenders did not have a compliance or ethics program in place. Approximately 0.2% of organizations were criminally prosecuted, criminally prosecuted received a sentence reduction under the sentencing guidelines because they had an effective compliance and ethics program. Only 1.5% received sentencing reductions for disclosing an offense prior to an investigation, in addition to fully cooperating and accepting responsibility. Department of Justice's criminal prosecution of companies may have declined more recently. However, their focus on individuals involved in criminal conduct has increased, as we saw earlier with the statement sort of shifting responsibilities. It's critical here to underscore the effects having a compliance and ethics program have on sentencing guidelines and whatever findings may come from an investigation of this sort. You'll want to have one in place. Next slide. So across all types of administrative audits, the top denial reasons include skilled services were not medically necessary. We see this a lot with, the patients could have performed these services themselves, or they had somebody at home who could have assisted with these sort of services. The initial certification was missing, incomplete, or invalid. A lot of times what I'm seeing with those is they may not have been submitted at the initial level. They actually do exist. They're in the medical record somewhere. They're just misfiled, or they weren't sent in because it didn't seem like it needed to be specifically included with a later certification period. The medical documentation submitted did not show the therapy services were reasonable and necessary. Therapy services were not of a complexity requiring a skilled therapist. Requested medical records were not received timely. That's a big one. Being able to keep up with the document requests that come from the variety of auditing contractors is crucial to ensure that A, you're getting paid for services and stay paid for services, but also to make sure that your error rates, which can affect later administrative actions, aren't getting too high just because you're missing deadlines. Sometimes that means, checking the online portal in addition to the mail. I am finding that some of my larger agencies will receive some things by mail and other things through the portal, and they may or may not be aware that different types of letters can be sent in different ways. One of the last things that we're seeing as far as denial reasons is deficiency in the face-to-face encounter. Next slide. So here are a couple of examples of cases under health enforcement actions. These come out of Texas. The first is out of the Eastern District of Texas, where a home health agency owner received 480 months in prison for paying illegal kickback payments to patient recruiters and his office employees for fraudulent use of Medicare and Medicaid numbers, and for an illegal co-payment type scheme with the referring and certifying physicians. among other varying bad acts. In the Eastern District of Texas, we have a defendant who was charged with conspiracy associated with billing Medicare and Medicaid for home health services that were not provided or were deemed medically unnecessary to the tune of $1.5 million. Next slide. In another case out of the Eastern District of Texas, home health company allegedly paid recruiters and doctors to bill for services using Medicare beneficiaries' information, regardless of whether those services were actually needed. In the Northern District of Texas, a physician and 2 nurses were found guilty for submitting or causing to be submitted false or fraudulent claims through a home health agency after certifying patients for medically unnecessary home health services and falsifying nursing notes to make it appear that the patients were qualified for the services provided. Finally, in the Southern District of Texas, an agency owner allegedly paid marketers and group homeowners for Medicare beneficiary information, which was used to bill for services that were either not provided or did not qualify for coverage and payment. So what we're seeing in those 5 cases, predominantly is medical necessity, improper use of beneficiary ID information, and using improper sources for referrals and paying kickbacks to those individuals. Next slide. Special focus programs monitor hospices deemed poor performers. These agencies are given additional oversight intended to enable performance improvement. Those who cannot improve may be terminated from participation in the Medicare program. The hospice provisional period of enhanced oversight started in 2023. It is a particular thorn in my side. Prior to its implementation, CMS received numerous reports of fraud, waste, and abuse related to hospice services over the prior 12 months, along with a simultaneous growth in the number of enrolled hospices. PPEO assesses agencies only in 4 states: Arizona, California, Nevada, and Texas. These agencies, it's not just a broad look at all agencies. These are considered just new agencies or those who have undergone a change of ownership. There's a very small, narrow category of agencies that fall into this. But you may think, well, my hospice has been around for 20 years. We won't fall under this. And then you have, certain administrative changes that occur, and that might put you right into the crosshairs for a PPEO audit. In these, we're seeing very small numbers of claims being reviewed and aggressive actions being taken subsequent to that review. One of my most recent revocation actions stems from a PPEO review of only 8 claims. The revocation was based on an alleged pattern or practice of improper billing based on the review of only those 8 claims. More than ever, new agencies, and all agencies for that matter, must ensure that every claim is bulletproof. The primary denial reasons we're seeing under SFP and PPEO include documentation does not support terminal diagnosis, physician narrative statement is not present or valid. With that one, sometimes I'm seeing the physician narrative statement, but it's not flagged or easily demarcated as such. You have got to hold the hand of reviewers, so make sure your EMR is appropriately titling each of these sections so it is indisputable what the reviewer is looking at. The election statement does not meet statutory or regulatory requirements. No certification for the dates billed. We want to make sure that when you receive an ADR for a specific certification period, you're actually including that certification that goes with that. Sometimes we'll have requests for dates that cross over certification periods, and you need to include the documentation for both of those periods. Reduction in hospice continuous care hours is another denial reason. Next slide. TPE audits, our targeted probe and educate audits, are intense, time-consuming audits, but they are a personal favorite of mine because it gives you multiple rounds of review and the opportunity for education. However, they also can lead to a referral for additional audits or even placement on prepayment review, each of which is going to require more time and resources from your team to prepare and respond. Your agency may also be looking at suspension or revocation. TPE denials primarily involve eligibility, face-to-face documentation, and missing or incomplete certifications or recertifications. TPEs may be initiated because your agency is found to have historically high denial rates, or billing practices that vary from your peers, or when there is evidence that suggests potential fraud. We're seeing a lot more data mining being used by the contractors, so it's less and less people are referring or acting as whistleblowers, even though we're seeing an increased number of those, and more that the numbers are shifting you away from maybe your peer group in the types of patients you're serving or the kinds of services that you're providing. So you're going to receive a notice that your agency's been selected by for TPE, followed by additional document requests. These ADRs may come in across multiple days, have different deadlines, and cover varying certification periods. I track everything with a spreadsheet so that I don't miss deadlines. I recommend everybody do the same or implement some sort of organizational standard that helps you meet those deadlines. Until your error rate drops below a certain threshold, which may differ between MACs and is generally not publicized, your agency will be subject to additional rounds of TPE, up to 3 rounds. Each of these provides an opportunity for education to discuss any denial reasons, documentation issues, or improvement steps that can be taken to avoid further denials. And that's what makes TPE probably my favorite of the audit types, because it gives you the opportunity to actually speak to somebody and discuss what they're seeing, what corrective actions you can take. Next slide. CERTs are a lot less common. We see them in much smaller proportions compared to other audits and the number of claims they review. The most recent CERT audit report reviewed 2023 hospice services, projected the improper payment amount during that time to be about 1.3 billion, which is calculated from an improper payment rate of 5.4%. This is significantly decreased from the year before when the improper payment rate was 12%. CERT denial reasons sound all too familiar: inadequate certification, inadequate election, untimely physician signatures, inadequate face-to-face, missing face-to-face. Let's go to the next slide. So SMRC audits conducted by Noridian most recently have included assessment of level of care billed. I don't see as many SMRC audits for hospices. These have been relatively infrequent in 2024, but because we're resuming the program, there may be expansion of the review focus this year. So be prepared for the possibility of seeing SMRC document requests. Denial reasons here are similar to those seen in other audits, like medical necessity, no response to the documentation request, you got to send in those records, or certification deficiencies. Core audit findings, again, can place a provider or agency on a path that may result in suspension or revocation. So that's a key thing to keep in mind, and ensure that the initial set of documents that you're sending in are the absolute best and most responsive documents you can to get you out of the audit process sooner. Next slide. Your team may be most familiar with UPIC audits. These audits are performed to detect, deter, prevent fraud, waste, and abuse. These are single round audits without the interactive education opportunities provided in TPE audits. These I say they don't have the interactive education opportunities. They do say their decision letters are educational, and they will classify that as your education when they're doing a review of previous audits. So these may also start with a small probe sample of generally 10 to 20 claims, and they may escalate to a larger sample of 20 to 40 or more claims that can then be extrapolated across a larger period of time. This is potentially devastating for small agencies. Denial reasons involve eligibility, consent, level of care, and licensure, in addition to those reasons associated with other audit types. You are provided with multiple levels of appeal. However, the opportunity to appeal may not translate to success. From 2012 to 2020, we've seen the rate of fully favorable appeals drop from 53.2% to 17.7%. This is not to discourage you from pursuing your appeal opportunities. Do take advantage of every chance to appeal a denied claim. Rather, it's more important than ever to ensure your documentation meets all Medicare requirements to get your claims paid, keep them paid, and allow you to continue providing medically necessary services and get out of that appeal audit cycle, which can be so time consuming. All right, next slide. So we've seen an uptick in OIG audits for hospice services in the last few years. Those are resulting in categorical denials associated with eligibility, documentation, and level of care. Sort of a subset of denial rationale is listed under each. OIG audits can be more time consuming and resource consuming than many other audits. Although we as a team recommend engaging legal assistance to address audits of all types, it is especially important when handling OIG audits. So you want to get counsel involved at the earliest stage possible, especially when you're dealing with OIG associated investigations. Next slide. So criminal hospice cases, here are two quick examples just on the criminal side of things. Out of the Southern District of Texas, the medical director in this case was sentenced for his part in the submission of $150 million in false or fraudulent hospice claims. He received 50 months in prison and was ordered to pay and forfeit nearly $20 million. In this situation, marketers falsified terminal prognoses. The medical director's fees and bonuses were contingent upon agreement to certifying unqualified patients for hospice in all kinds of ways. They couldn't have made poorer choices. In a case out of the Northern District of Texas, a hospice owner agreed to pay over $4 million to resolve false claims allegations. The claims were submitted for patients who were ineligible for Medicare hospice benefit because they were not terminally ill. We are seeing and it's not just on the OIG side of things, but across all audits, a big question of the terminal prognosis when it comes to our hospice patients. In many cases, when a hospice patient exceeds that 6-month time frame, especially if they exceed it on several occasions, we're really seeing the contractors question whether that terminal diagnosis was proper. And it is up to your documentation to show why that terminal prognosis in the very first certification period was correct, despite the fact that maybe the illness didn't take the expected course. So we want to really make sure, again, your documentation is fantastic as soon as absolutely possible before you start getting into the audits and appeals process. I'm going to switch it over to Matt, and he's going to start chatting about the anti-kickback statute and some of the provisions there.
Thank you, Christin. So as a bit of the background, the anti-kickback statute began as evolution of the scienter and intent requirements. It stated whoever furnishes items or services to an individual that incorporates, in layman's terms, any kind of kickback, remuneration, referral fees, any kind of uptick in compensation based on you send patients our way, we'll give you X, whatever X is. In 1980, the Omnibus Reconciliation Act amended the Social Security Act to require proof of both knowing and willful conduct. In legalese, that is sometimes referred to as the scienter elements. Next slide, please. Currently, the anti-kickback statute codified at 42 USC et sec is a crime to knowingly and willfully solicit, receive, offer, or pay for any remuneration in return for 1, referrals or arrangement for services payable by any federal or state healthcare programs. That means no referrals for anything that touches the federal or state piggy banks, followed by any purchasing, leasing, ordering, or arranging for any goods, facilities, services, or programs that may be paid for in whole or in part by any federal or state healthcare program. Once again, your big tip-off here is if it touches the federal or state piggy bank, they can sometimes invoke the anti-kickback statute depending on the behavior alleged to be at fault. Under section 6402F2 of the ACA, a person does not need to have actual knowledge of this section, meaning ignorance of the law is not a defense, and they also don't need to have specific intent to commit a violation of this section, meaning their behavior can run afoul of the anti-kickback statute without them saying, whether openly or amongst themselves, we're going to break the law. It can just run afoul despite the best of intentions. This change is very noteworthy because it very much lessens the requirements needed for the government to bring criminal cases and criminal liability under the anti-kickback statute. Next slide, please. So the penalties for these criminal cases brought under the anti-kickback statute can first and foremost result in prison time, up to 10 years in prison per alleged violation, followed by a fine of up to $100,000, exclusion from participation in federal and state healthcare benefit programs. That is sometimes referred to as the medical death penalty, just due to the sheer scale that Medicare and Medicaid patients play in terms of payer pools and what providers are seeing. If you are excluded from the programs, it means you can't bill those programs, full stop. Finally, civil monetary penalties up to $50,000 per violation and assessments equal to not more than 3 times the amount of remuneration paid under the agreement. The 3 times number is sometimes referred to as the treble damages provision. It is supposed to be used in instances where excess bad behavior is noted and to deter other people from emulating that behavior. Unfortunately, it has been used more generally than that. Express intention is the polite way to frame it. Most courts have adopted a very expansive reading of the knowing and willful intent standard that we previously discussed under the federal anti-kickback statute. The Third Circuit adopted the one purpose test in the Greber case cited on your screen. The one purpose test states if the payments were intended to induce the physician to use a, quote, bad actor, end quote, services, the statute was violated, even if some payments were also intended to compensate for professional services, with emphasis applied there because even if some transactions are legitimate, if there is one that the government can point to and say, this violates the anti-kickback statute, the whole batch can be tainted. One apple spoils the bunch, essentially. Next slide, please. There are a few safe harbors to avoid anti-kickback statute liability. The scope of potential coverage under this law is extraordinarily broad, and in recognition of this fact, in 1987, the Congress authored DHHS, the Department of Health and Human Services, and their OIG to create safe harbors for certain business arrangements and practices that, while they may otherwise potentially be a violation of the law, if it qualifies under a safe harbor, they'll let it go. All safe harbors are voluntary, not mandatory, and while a given arrangement is not necessarily a violation of the anti-kickback statute if one or more of the elements in a safe harbor have not been met, a provider is effectively precluded from relying on a safe harbor as an absolute defense. Translated from legalese, that means safe harbors are very particular. They have a very distinct checklist per safe harbor, and if you fail any item on that checklist, it precludes you from using that safe harbor as an otherwise bulletproof shield to the liability under the anti-kickback statute. The number of safe harbors within the AKS is subject to change per congressional discretion. There are currently 11 statutory and 36 regulatory safe harbors. Next slide, please. So the most likely safe harbors to arrive in a home health or hospice compensation are the following two: the personal services and management contract safe harbor, as well as the employment safe harbor. As I mentioned previously, both these safe harbors are quite complex and usually require a legal assessment to determine whether a proposed business arrangement qualifies under a specific safe harbor. We recommend retaining counsel if you intend to engage in behaviors that you would want to use a safe harbor to protect, and make sure that all elements of that safe harbor are protected before you proceed with the possibly bad business arrangement. Cover yourself ahead of time before you end up in front of the AKS or in front of government investigators. Physician ownership of home health or hospice agencies may be protected under the small entity safe harbor, but compliance is very complex and meeting every element of that safe harbor is generally impossible. Consult healthcare counsel before attempting to use any of these safe harbors. Next slide, please. On your screen is a breakdown of the personal services safe harbor. I'm not going to read every word in the interest of everyone's time, but I will point out some key points. Specifically under specifics, remuneration does not include payments made by a principal to an agent as compensation for the services, so long as the following are met. There is an agreement in writing signed and executed by the parties. The agency agreement covers all of the services the agent provides to the principal for the term of the contract and specifies the services to be provided by the agent. The term of that agreement is not less than 1 calendar year, and the methodology for determining the compensation is either set in advance, or is set in advance, consistent with fair market value, and is not determined in any manner that takes into account volume or value of any referrals made during the term of the agreement. Next slide, please. The employment safe harbor is the other one that we usually see in a home health or hospice agency. The bona fide employee safe harbor to the AKS states there is no violation of the statute for payments made by an employer to a bona fide employee who has an employment relationship with said employer for employment and the provision of covered items or services. It's a whole lot of legalese to say bona fide employees are usually all right, depending on whether or not you qualify under the safe harbor. This safe harbor is an affirmative defense, which means the defendants have the burden of proving compliance as opposed to it automatically instituting itself as a shield. The Fifth Circuit has found safe harbor provision adopts the definition of employee set forth in the United States Code. And they further noted that the Supreme Court has held where a federal statute adopts a common law definition of employee, the term incorporates the general common law of agency rather than the law of any particular state. Translated from legalese, this means federal common law controls, not any individual state law, which can be a double-edged sword as it cuts out some protections that states may provide, but also gives you the full breadth of a universal, these are the rules on the federal circuits. Next slide, please. Medical directorships are a current hot button topic and area of enforcement for OIG and their federal and state counterparts. The OIG in 2015 issued a fraud alert entitled Physician Compensation Arrangements May Result in Significant Liability. It serves as a clear warning both to physicians and the organizations that employ them. The OIG alleged that compensation paid to medical directors under their medical directorship arrangements constituted improper remuneration under the AKS for a number of reasons. These include the payments took into account the volume or value of referrals and did not otherwise reflect fair market value for the services to be performed. The OIG also alleged that some of the 12 physicians outlined in this notice had entered into arrangements under which an affiliated healthcare entity paid the salaries of the physician's front office staff. These arrangements relieved those physicians of a financial burden they would otherwise have incurred and therefore constituted improper remuneration to the physicians. The short version of this is to make sure your medical directorship arrangements with however many medical directors you have and what they do is ironclad so that you can stay out of court before an issue arises. Next slide, please. There are recent kickback risk areas of enforcement that we've noticed an uptick in. On your screen are business arrangements with individual entities that has the ability to refer business to your home health or hospice agency. There's always a continuing concern of lease arrangements, as we mentioned, medical directors as well. Old school dine and dash approaches are usually gone and have not really, they've really phased out in recent years. However, lunch and other goodies being brought to a practice office is still both commonplace and can be viewed as problematic. Sham arrangements where loans, research grants, speaking fees are paid to entities from which you receive referrals are also viewed as remuneration and are a current example of problematic conduct. Cash, gifts, or other items of value are particularly where you're going to see AKS enforcement upticks. Remuneration does not just mean a monetary amount. It can mean items of value, including gift cards, sporting event tickets, and especially liquor. We have seen increased focus on gifts of rare or expensive alcohols being given and that qualifying as remuneration under the anti-kickback statute. So short version, don't give anybody anything that's not fair market value and that you can't back up as fair market value, or you run the risk of running afoul of the AKS. Next slide, please. False Claims Act is a separate statute, and it was long time viewed as separate and distinct enforcement tools, with the False Claims Act used in civil matters and the anti-kickback statute being in the criminal case. However, over the past 20 years, this landscape has slowly changed, beginning in the early 90s. Whistleblowers asserting key terms began stating that violations of the False Claims Act occurred where an anti-kickback statute was implied. These cases often involve fact patterns where a party was alleged to have violated the anti-kickback statute and, in the process of the violation of the anti-kickback, billed for services allegedly worthless, and therefore made false, express, or implied certifications to Medicare or Medicaid. The 2010 passage of the Affordable Care Act obliviated or took away the need to bootstrap a violation of the AKS to a violation of the False Claims Act. Under the ACA, a claim submitted in violation of the AKS, the anti-kickback statute, automatically constitutes a false claim for purposes of the False Claims Act. That means that the government can and will pursue simultaneous criminal and civil liability against your institution if they have reason to believe an AKS violation occurred over a period of time where claims were submitted to state or federal Medicare or Medicaid programs. They will come after you both criminally and civilly on the same facts post the ACA. Next slide, please. There are also revocation actions on the rise prior to the 2019 expansion. Primarily, the CMS noted 22 reasons for revocation of Medicare or Medicaid billing privileges. The first, obviously, being non-compliance with the program's many interesting regulations, statutes, and rules and guidelines. Felony convictions are also top 5 on the list, as well as providing false or misleading information. Failure of on-site reviews, failure to report, and termination under one or more adjacent Medicaid state programs also were noted to be reasons or grounds utilized to revoke a provider's ability to bill the federal Medicare program. Improper prescribing practices and debt referred to the United States Department of Treasury are noted to be added to the list and growing areas of concern, just to point them out and make you aware of them. Finally, of course, there is abusive ordering, certification, referral, or prescribing of a part of A or B services, as well as always, instances of patient harm. Next slide, please. Additional proposed revocation authorities became bases for revocation as of January 1st of 2024. The non-compliance revocation ground, all enrollments requirements, regardless of their placement in Title 42. Several expanded the enrollment requirements that providers must meet in order to continue billing Medicare. Misdemeanor convictions have been modified expansively. CMS modified the language under the misdemeanor conviction language, so they revoke an enrollment if any owner, managing employee, organization, officer, or director thereof have been convicted of a misdemeanor under federal law within the previous 10 years. False Claims Act civil judgments also serve as grounds for Medicare revocation, as well as violation of provider and supplier standards, and once again, debt, as is referred to the United States Department of the Treasury. Next slide, please. When responding to an investigation, we generally recommend that you avoid half-truths, lies, and be aware of audio tapes. While the world of law enforcement may have advanced, the FBI specifically is not giving up one particular thing. We have seen a significant increase in the use of body cams. These cameras have been used to exonerate defendants in some cases, whereas in other cases they have solidified the government's arguments and provided ironclad evidence against physicians or providers who are in the hot seat. If you are interviewed by the FBI, in most cases, they will not tape record the interview. It is common for FBI agents to work in pairs when an interview is ongoing, especially with non-custodial suspects or witnesses. Instead, they will take notes of their interview on an FBI Form 302. Juries have been known to give weight to the version of the events documented in the FBI Form 302, regardless of whether or not those are overall contested versions of events. Since the FBI agents typically work in pairs and will readily support one another at trial, it can be very difficult to overcome the version of facts documented in the FBI Form 302. With these in mind, what should you do if you are approached by an FBI agent or another alleged federal investigator? Next slide, please. First and foremost, you cannot lie to them. Under no circumstances do we encourage, recommend, support, or advise that you ever lie to a government agent or investigator. Their investigative process is very thorough and it will come out in the wash. The other side of that coin, they can and absolutely will lie to you. It does not render any statements against your interest that you make involuntary or inadmissible just because an agent lies to you, and they will use this to their advantage. The U.S. Supreme Court has addressed this issue in Frazier versus Cupp. A homicide suspect was interrogated by the police and falsely told them that an accomplice had already implicated him in the murder. Based on this lie, the suspect confessed to the murder. The U.S. Supreme Court ruled that the use of trickery and deceit can be permissible, depending on totality of circumstances, provided it does not shock the conscience of the court or the community. Further cases supporting this are Sorrells versus the United States and the United States versus Russell. The quotes supporting the use of deceit or trickery are on your screen. Examples of conduct, however, that does shock the conscience of the community. An investigator lying about his identity and introducing himself as the defendant's court-appointed attorney does shock the conscience. An investigator who poses as a clergyman in an effort to obtain a confession under the guise that would constitute a behavior that shocks the conscience of the court or community. You can't pretend to be a priest, is the short version of that. Finally, courts have upheld over the years countless confessions, even though the investigator lied to the defendant during an interview. These cases have typically involved situations where the investigator made false statements about certain evidence, eyewitness testimony that the government would depend on, or the presence of fingerprints, among other things. The short version is that government agents can and will lie to you and use deception and trickery to get more compliant answers out of you if they believe there is something to investigate, and they are rarely punished for doing so, and it also does not wave away the evidence of your statement. So you need to be very careful when investigators show up on site. Next slide, please. Misstatements, hyperbole, and exaggerations can result in prosecution. Everyone has a tendency to wax poetic at certain points and under high stress, but we strongly encourage you to be very careful with what you're saying to federal investigators. In a case out of Spokane, Washington, the government conducted an investigation of the controlled substance prescribing and billing practices of a licensed, authorized healthcare provider at a local clinic. 99% of the time, he checked the vital signs of a patient before prescribing opioid medication. In truth and in fact, the healthcare well knew that statement was materially false when made because he did not check the vital signs of a patient 99.99% of the time. The rate at which the clinic performed these complete physicals was materially lower. And while that may have just been a statement out of hand, they did hold it against that provider in court. Notably, the government did not charge the healthcare provider with any billing-related violations. They did not charge them with any controlled substance or prescribing act. They relied on charging the defendant with, quote, making a materially false statement to the FBI. That defendant is now facing a potential sentence of 5 years in prison and a possible fine of $250,000. Once again, if and when investigators show up, do not lie, and especially do not misstate or hyperbolize what has actually occurred. Next slide, please. The final thoughts related to personal culpability. Self-audits are not just encouraged, they're strongly required if a company wants to be viewed as a good corporate citizen. The more documentation you can put in front of federal investigators detailing self-audits and compliance efforts, the better it is for you and your attorneys if and when the heat gets turned on. Potential overpayments must, and I stress again, must be promptly investigated and returned to the appropriate payer. You must remain mindful of the DOJ's renewed interest in individual accountability. They can and will pursue both corporate entities and the individual physicians who support and make up those corporations if the facts allow them to do so. Finally, we recommend documenting your efforts to fully comply with applicable statutory and regulatory requirements, and when in doubt, consult an attorney. Next slide, please. All right, just as a reminder before we head to questions, everything provided in this outline is general information only. It is not legal advice. Christin and I are attorneys. We are not your attorneys, and nothing in this slide deck should be used as substitution for fully retained and engaged counsel. I think that takes us to questions.
All right, so I only see one question listed, and just to answer it, for anyone else who has a similar question, CEUs are not offered with today's webinar. But outside of that, I want to thank you so much to our presenters, and thank you to all of our attendees for joining us today. I'll be sending a copy of the PowerPoint slides tomorrow. If you have any further questions, please feel free to reach out to Christin or Matt. I hope you all have a great Tuesday.